defendant suddenly arrived at the third level where she was located and began to yell and scream at her, and it stated he threatened to beat her ass.
Did you say she was in fear? Because a lot of people make these stupid ass threats all the time, and it's just... Tell me what it says.
What you just watched was the moment a parking garage situation turned into a criminal case. But there is another important part of this story that you may not have noticed. This is the case of State versus Mr. Mumford. At first, it looks like a simple workplace argument. But legally, the question was much more serious. Was this just an angry argument, or did Mumford actually make a terroristic threat? Mumford was accused of cornering a coworker on the third level of a parking garage and making threatening statements. But as the hearing continued, the story started to become less clear. The prosecutor said the alleged victim was afraid, but Judge Fleer noticed something important. The actual reports did not clearly say that the victim was afraid. That raised questions about whether the evidence was strong enough to continue the case. Mumford was facing up to 6 months in jail and a $2,000 fine, so the stakes were serious. Now let's go back to the beginning and see what really happened in that parking garage.
Mr. Mumford, you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On October 4th, 2024, officers were dispatched to a call at a parking garage in Harris County, Texas. Officers made contact with a complaining witness who stated that she and her coworkers, including the defendant, were working inside the parking garage. And the complainant messaged the defendant asking where he was located, and the defendant suddenly arrived at the third level where she was located and began to yell and scream at her, and it stated he threatened to beat her ass.
Were they together at the same place?
They were on the same, so they both work at the parking garage, I believe, and they were both on the same level. Like it was in person, the threat was made in person.
Did you say she was in fear?
I don't see that in the Dunes, Judge, but let me really quickly get the offense report. I don't see that alleged in the OR, Judge.
Mumford.
So the only thing the state would say, Judge, is our position is, I know it doesn't say that complainant said she was in fear for her life, but the charging instrument, it's not one of the elements we have to prove. We just have to prove that the defendant intended to place the complainant in fear of serious.
I don't know. Let's see. A person commits an offense if he threatens to commit any offense involving violence to any person or property with intent to place any person in fear of imminent serious bodily injury.
So, and Judge, just to remedy the issue, we checked the probable cause affidavit on the charging instrument. On the PC affidavit, it does say that she stated she was in fear for her life.
That's the only thing I want to know is she in fear? How do we know?
Yes, Judge.
Because a lot of people make these stupid ass threats all the time and, it's just,
I understand, Judge.
tell me what it says. And does she say that she was in fear?
Let's see, it does say that the defendant came to level 3 where she was located. He began to yell and scream at her, threatened to beat her ass. She stated that this scared her and made her in fear of serious imminent bodily injury.
And where is that?
This is in the charging instrument, the PC paragraph.
That's just the charge. But I get it. That's just because they put that in the charge. Nowhere in the OR does it say that she's in fear. Nowhere else does it say she's in fear. That's just because they always put that on every information with regard to this.
I understand, Judge. And
Yeah.
the only position we have is that it's not one of the elements the state has to prove.
I don't agree. I'm going to find no probable cause in your case. The only thing I'm going to tell you is be careful, really. Words
Yes, sir.
have meaning. Words can hurt, right? Pen is mightier than the sword. Words can hurt. Just be careful. All right. Okay. Take a seat, please.
In the end, Judge Fleer dismissed the case after finding that there was no probable cause. Mr. Mumford walked away without a conviction. But that leaves us with an important question. Was justice served, or did Mumford simply benefit from weak evidence? What do you think? Team Mumford or Team Prosecution? Should angry or threatening words alone be enough to send someone to jail? Or does the prosecution need stronger evidence to prove that a real criminal threat was made? Let us know your opinion in the comments. If this case made you think, hit the like button and subscribe for more courtroom breakdowns.